Now, as important as it is to understand what DACA is, it is also important to understand what DACA is not. First of all, it is not legal status. It does not grant the individual that has an approved DACA application status in the United States. They are basically in the same status as they were when they applied or were granted DACA, and for most that means they have no legal status. It is not a path to a green card. Unlike what the DREAM Act would have done for the Dreamers that were qualified to apply, DACA is not a path to a green card. DACA is also not a path to citizenship. And finally, the most important thing to remember is DACA is not law, which means that if President Obama woke up tomorrow morning and decided he no longer wanted to continue the program, he could just end it. And that's very significant to understand, especially when you communicate to your clients the benefits and the pros and cons of applying for DACA. As long as the program is in place, they are protected from deportation, but the minute the program ends, they are back to the status that they originally were. Now, where does the DREAM Act stand today? Well, as we talked about earlier, the DREAM Act has still not passed Congress yet. In Comprehensive Immigration Reform Bill S-744, which was introduced and passed by the Senate last June, key provisions of the DREAM Act did make it into the bill. However, early this year, the House has pretty much unequivocally stated that they are not going to conference on that bill. Since then, there have been different versions of the DREAM Act. One of them is the KIDS Act, another one is the STARS Act or the ACHIEVE Act. A lot of them boil down to the same thing, what to do with all these young individuals. They came illegally to the United States, but did so at such a young age and know no other home but the United States as their home, and have contributed by getting an education and serving in the military. Members of Congress still feel that this is a very important piece of legislation, and what they have done is pass many state-level DREAM Acts. And I know that gets really confusing, gets even me confused whenever I read in the news the DREAM Act was passed. I think it's passed Congress, the federal DREAM Act is passed, and it hasn't. Most of what you hear in the news these days is state level or state versions of the DREAM Act being passed. And what that does really depends and varies from the state, but most of it offers tuition assistance or affords the Dreamers that would have qualified for the DREAM Act for in-state tuition prices. And some of them even set up private grants from private donors that set up funds to assist with tuition assistance. What if these applicants, before they left the country to attend their interview, could jump up a few steps and apply for the waiver first? What if they could find out before they even left whether or not their waiver would be granted? If the waiver was going to be granted, they knew for sure that the green card was likely going to be granted as well. And so if they left the country, triggered the 3-10-year bar, they wouldn't be worried. They would basically have an insurance card or some protection that that's fine because now my waiver will be granted, it's safe to leave the country. Or in the converse, if they knew in advance that their waiver was going to be denied, then they knew that they would not leave the country, so they wouldn't trigger the bar, and ultimately they really needed to find some other path to getting a green card. So that is what the provisional stateside waiver did. If the adjudicating officer determines that the person may be inadmissible on any other grounds, then the person is not eligible for a provisional waiver. Now, this last requirement has been really, really frustrating for immigration practitioners, because what that basically did was give the adjudicating officer really broad discretion to deny many applications. And since this program or this new provisional waiver took effect, which was March 2013 last year, about 60% of the applications that have been submitted have been approved. And most that have been denied on this last ground. It is because the adjudicating officer determined that the person may be inadmissible on other grounds. Not that they were, not that they actually even really looked into it and determined that they actually were inadmissible, but if they thought that they may be. And usually what happened was, if the officer looked at the criminal record of the applicant and saw that they had a prior arrest, even if that arrest was for a misdemeanor, qualified as a petty offense exception, was a traffic violation, or any other thing that normally would not even qualify or be determined to be a criminal conviction or render the person inadmissible, the officer would just state that, well, I see an arrest, you may be inadmissible on other grounds, and they were denying the applications. But included in your packet is a recent memorandum, a guidance memorandum issued by USCIS, which clarified the USCIS's position on this. They are now saying that that should not be a reason to deny these applications. And in fact, people that have had their applications denied for this reason could reopen it and have it re-adjudicated. The thing to remember about same-sex marriages is that immigration is going to look at the place of celebration rule. As I mentioned earlier, not every state in the country recognizes same-sex marriages. And so to determine whether or not the marriage is valid for immigration purposes, immigration will look at the state where the marriage was celebrated. And if it was celebrated in a state that recognized same-sex marriages, then it would be considered valid for immigration purposes. Even if the couple no longer lives in that state, and even if the couple didn't make the application for a green card in that state, immigration would still recognize the marriage as valid, and they would afford all the benefits for the same-sex couple as they would afford heterosexual couples. And this really spread to all immigration benefits besides family-based immigration, which we just talked about. It would qualify them to be qualifying relatives for the waiver that we just talked about, and any other waivers where the qualifying relative was a U.S. citizen spouse. Now, a same-sex spouse would also qualify. They qualified for derivative benefits, for fiancé petitions, and even for abused spouse self-petitions.